Welcome, welcome. Welcome, welcome. Beginning a few. All right, tonight we want to talk about collections and the trends that are in play in the collections game. If you are a CRO or you are a regular consumer, you must be aware of these trends because they will affect you one way or another. So tonight I just want to discuss a few of the trends that are important for us to understand as we navigate the credit repair setting. The collections account prior to COVID, there was a certain level of activity within the court system. And during COVID, those activities were basically lowered because the court systems were shut down. The court systems were also, the activity was minimal. And because of that, there were some downturn within the activities within the courts. But since 2023, there has been some uptick in the activity within the court system. So tonight, I just want to cover a few other things that we should be mindful of once we are dealing with debt collectors, if we are CROs or whether we are consumers. In the court system, a lot of changes has been made since 2015, 16. A lot of changes were made because of the uptick in collections account. And as a result of those changes, COVID also slowed it down. Some of those changes are in place currently, and we have to be aware of our state laws to realize the protections that are there. However, since COVID, um, a lot of things has changed in the landscape, such as AI, such as the system being overwhelmed where the economy is concerned because of the downturn in the money that was pumped within the system during COVID. After COVID, a lot of that money went away, and as a result, a lot of debt is outstanding. If you have a consumer as a client or you are the consumer yourself, you got to be prepared for this. There's a lot going on in the courts where debt collections are concerned. So tonight we want to discuss that. Over the weekend, there is a very viral piece, an article that came out in the New York Times that individuals are discussing. But that article is not an original piece. It is built on a lot of the research that is being done within the court system. And one of the trends that are currently peaking is debt collectors are taking more and more individuals to court. If you are a CRO, if you're a credit repair company, you gotta be prepared for this. If you have clients as a credit repair company and they have collections account that they're delinquent on, especially if those accounts are sold to debt buyers, be prepared for those clients to be sued. Not because of what you are doing, but because of the trends that are taking place in the system. If you are a credit repair company or if you're a consumer and you have delinquent account, prepare yourself because the debt buyers and some of the furnishers, especially if you have debt from certain banks, Capital One, Discover Bank, Credit One Bank, those banks love to sue. If you have debt from those banks, be prepared to defend yourself and be prepared to stand up against debt collectors if they attack. The trends that are peaking, it's throughout the country. It's not just in certain areas. Whether you're in a rural area or you're in cities, there's an uptick in collections lawsuit. One of the things that debt collectors are doing, they are implementing AI in what they're doing. So just as how a lot of individuals are using AI to do credit repair, are using AI to do their disputes, debt collectors are using it to fast track and ramp up their caseload because lawyers or paralegal doesn't have to spend as much time as they used to draft up their cases. So as a result, they're implementing AI and they're flooding the court systems. One of the major companies that are doing a lot of damage, and with the record that is being collected, what it is showing, if you have an LVNV account that is delinquent, more likely than not, you're going to be sued. LVNV is up at this point, but from pre-COVID times, over 325%. They're ramping up their lawsuits in terms of what they're doing. So if you have a LVMV account, be prepared, prepare yourself. If you have a Credit One account, be prepared, prepare yourself. If you have a Capital One account, be prepared, prepare yourself. If you have a Discover Bank account, prepare yourself. These are some of the people who love the system. Midland Funding, Jefferson Capital, all of these guys are ramping up what they're doing in the court system. So we have to be prepared once we are doing credit repair. How you become prepared is by educating yourself. Educating yourself on the nuances of debt defense. You gotta be prepared to, if you're not gonna give legal advice as a credit repair company once you're not a lawyer, but you can provide educational advice that become helpful to your clients. Because one of the things that you will find is that most of your clients will not be able to afford an attorney. They're not going to be able to afford an attorney. The average debt collection lawsuit throughout the country is about $1,500 on average. Now, the average attorney is going to charge anywhere from $2,500 to $3,000 and change, or even more, to represent it. This is not like when you have a FCRA violation or another violation like that, where you are able to get an attorney to work on it for you, and then upon winning the case, they take payment. Collections lawsuit are different. Collections lawsuit requires you to pay the attorney for the most part, unless it's a pro bono suit where you get help from a legal aid society or some form of consumer advocacy groups that will help you to defend yourself and don't take payment. But for the most part, you will have to pay for this. Therefore, the average client or consumer does not have the money to actually pay for this. So the next best thing is to have the knowledge to end up defend yourself. If you don't have the knowledge, you are going to fall victim to these companies, because what they're banking on is that they're suing you is a strategy. Suing you is not random. It is a business strategy. A lot of these big debt buyers and big banks are publicly traded company. So they are after their bottom line, which means when they come by an account, they have collected on that account several ways, from the tax write-off, having it as a charge-off. They sell it off to debt collectors and make money there, and several other ways. They actually have the power, even if they spend money in litigation to pursue you, to get that back as tax write-off. So you have to understand how you are going to navigate the system so that you are able to protect yourself and educate your client. You are not going to be able to get around this, because it's becoming worse and worse. With AI on the rise, AI is making everything easier. Even in the credit repair industry, AI is making a lot of individuals who are running their business operate with much ease. But one of the problems that we are having with the rise of the use of AI in the credit repair space is that we are shying away from educating ourselves, because we can just get ChatGPT to write a dispute letter, to write a follow-up letter. So we are not spending the time to understand the nuances of the law, where we can use it to defend ourselves outside of just generating a letter. If you don't understand how the system works, you will not understand how to move in your disputes. So debt collectors are suing in a more aggressive way. One of the issues that we have within the debt collection space is that within the debt collection space, they have all the tools to ramp up what they're doing. When the debt collector purchases, which most people don't understand how the debt collection industry works. When a debt collector purchases a debt, the debt collector gets with that debt a debt score. That debt score tells the debt collector how likely or not you will be in paying that debt. What the debt collector actually does is also, after they purchase that, they plug those accounts in their system and use their algorithm and metric to determine whether or not they should pursue you in the courts or they should just use the regular route of collection. Suing you is a method of collecting. It's one of the more easier way to enforce. It's costly, but if the debt collector files a lawsuit, we don't turn up, and after not turning up, they get a default judgment, that makes it easier for them to collect. Because with the default judgment, they can garnish our wages. They can cease, put liens against bank account, and so on and so forth. Now, so what the debt collectors do is they make sure that they are leveraging the court system with, they have law firms. How it works, let me run it back and give you the sequence. They purchase the debt. After they purchase the debt, they select a certain amount of debt to sue on. After they select those certain amount of debt to sue on, they also forward those debts out to their law firms that they have that works with them. So it's not like they're going to look for a lawyer or to hunt down a lawyer. They have law firms strategically placed in different cities that do the collections for them. Once they send off that lawsuit, they have a system that they use, right? A lot of times when you actually have a case against debt collectors and they see that you are basically having an advantage, one of the things that they like to do is to make you an offer to settle, because they know more likely than not that if they pursue this case with you, they're going to lose. And in the end, what the debt collector is about is collecting their money. So if it is the case that they're able to collect their money back from you by settling, that's what they want. They don't mind settling for less than what they actually spend, because they buy these debt for pennies on the dollar. They don't spend a lot of money to buy these debt. As a result of buying these debts for pennies on the dollar, their objective is to maximize the profit that they have spent. What you have to do is be able to understand the foundation and fundamentals of debt defense. Once you understand that, you can challenge any of these debt collectors. Because for the most part, these debt collectors doesn't have the data that they need if you are going to take the fight to them with the case. For the most part, they don't have the data. But if you don't know how to challenge them, they are going to go to the court and basically use the court against you. One of the things that I always tell my student or anyone that I actually work with in an educational capacity, and this is not legal advice, I don't give legal advice because I am not an attorney. What you want to do when you're dealing with a debt collector or a lawsuit, you want to win that case on the basis of your paperwork. Why I usually say this? Because when you go in that court and you do not have an attorney and you are representing yourself, there is a bias that is in the system against you. Whether or not you want to believe this, that's up to you. There's two different biases at work. One, you don't know the law the way how an attorney knows it because he's doing that every day. He's living. So the judge, from that perspective, is a bit more cautious in what they will allow you to get away with. While an attorney can get away with things that you wouldn't be able to get away with. Secondly, the judge was an attorney. The other side, lawyer, is an attorney. They see each other as colleagues. So there is a bias that you will have going in. So once you are dealing with collections lawsuit, you need to win your lawsuit on paperwork, especially at the motion stage. You want to win on paperwork so that you don't have to face the judge, because the judge can be extremely biased. For example, I have seen cases where dispute exists between banks, and there are several of these cases where the bank will go to the court and the bank will say, we need X, Y, and Z, we need arbitration, for example, from you in order to get the case out once the consumer sue it. And the judge will say, okay, grant you the arbitration to the bank. But when that is done, the bank will tell the consumer they must go and file the arbitration, right? Because even though it's the bank who elect for the arbitration. Then you have the same case with the same bank, but a different individual. In this case, the individual elects for the arbitration. When the individual elects for the arbitration, the judge grants it. But in this case, the bank again is requesting that the individual goes and initiate the arbitration. So you have one case where the bank elects it and they're telling the individual to go. You have another case where the consumer elects for the arbitration and the bank is telling the consumer to go. And the judge sides with the bank in both cases. Why? Because the bank, as a lawyer there, the consumer is representing themselves. So you want to educate yourself to the point where you can win the case without ever going to court. And when I say go to court, meaning to face the judge face to face or in trial, you want to win it in your motions, especially in the early stages where the judge listens to most of these motions without you having to present oral arguments. So you want to be prepared to deal with these banks. If your client or yourself has a lawsuit with LVMV funding, more likely than not, prepare yourself, you might get a lawsuit. If your client owes Capital One, prepare yourself, you might have a lawsuit. If your client owes Discover Bank, prepare yourself, you might have a lawsuit. And Discover Bank is now merged with Capital One, so they're going to be more aggressive. If your client have an account with Credit One, prepare yourself, because most of LVMV funding, more than half from the data that is present in the court record, more than half of LVMV funding cases is from Credit One Bank. And we know that Credit One Bank is a subprime lender. Capital One, some of its product focusing on subprime lenders. One of the trends that also is present within the data throughout the country, not just now, but throughout the entire different studies that have been presented. If you are a minority, prepare yourself. Once you default, you are more likely to be sued than somebody else that is not a minority. There are several reasons for this. One, they know that more likely than not, you will not be able. And this is not saying that a minority cannot afford an attorney. This is the trend that exists. More likely than not, a minority, especially if they are in certain neighborhoods, will not have the funds to hire an attorney. Because as I said, the average lawsuit is $1,500. Some of them are more. Will not have the funds to hire an attorney. As a result of that, it is incumbent on you to have the knowledge to defend yourself or to educate your client if you're a credit reporting company from a non-legal perspective, purely from an educational perspective, so that they can make the decisions on their own, not from your advice, to defend themselves. If you are a minority, you are more likely to be sued than another demographic. Why? Most people don't turn up to court in the lawsuits that we have seen. Most people, if they do turn up, they don't know the law. They also don't turn up with attorneys. Once they turn up, the court is going to force you, and not force, suggest to you to do a settlement. The debt collector or the bank will jump for this, because the main objective of going to court in the first place is to collect their money. As a result of this, it is important that we equip ourselves, that we have the knowledge to be able to navigate the circumstances that we are facing. If you are not able to do that, you are going to find yourself in problems. Again, let me run back the banks. LVMV funding, debt buyer. Credit One, right? Credit One, big time, suing like crazy. Discover Bank, suing like crazy. Capital One Bank, suing like crazy. Chase, for a time, because of the damage that they incurred to the robo-signing scandal that they were a part of a few years ago, they backed off for a while in suing, but they're back at it. Chase is back at it in suing again. Citibank, one of the ones that is also aggressive. So once you have account from any one of these major banks, you are going to be in problems, and it's getting worse because of AI. So as you run your business, please do not allow AI to allow you not to educate yourself. Use AI to become more efficient, but educate yourself. Once you educate yourself, you will be able to help more of your clients in their situation. As I said, from a non-legal advice perspective, you can have workshops and showing how you go about doing debt defense. And that is why in Gyronic University, one of the things that you learn, not just to do credit repair disputing, but you learn debt defense, because debt defense is important. And right after COVID, the money that was there before and a lot of the credit that was acquired is defaulted on. Where the economy is at this time, most people don't have money. And because they don't have money, the debts are piling up and the debt collectors are extremely aggressive. One of the things that you need to learn to do in dealing with debt collectors, you need to understand your rights. You need to understand how to dispute with the debt collector from a position of power. What I mean by this, what is meant by this is that the debt collector understand that they're dealing with someone that is knowledgeable. You cannot just be using the little tricks that are floating all over the place. Your dispute must be grounded in legal arguments, grounded in contract law, grounded in the requirements of contract law, grounded within the proper evidence to prove a claim, grounded in the proper evidence to basically prove an alleged accusation that you owe a debt. If you don't understand these things, the debt collector will realize that they are dealing with somebody that is uninformed, and they will apply pressure. One of the quick things that we are told once a debt collector contacts us, cease and desist. Yes, cease and desist is good, but it doesn't mean that the debt goes away. And once a debt collector realizes that they're not able to communicate with you to give them an opportunity to work out some form of agreement where they can get payment, they are going to try and sue you. And in that case, your cease and desist is out the window. Not from the perspective of them communicating, but it won't matter anymore, because now you have a case on your hand that you have to answer, and that the debt collector is going to make a claim that you owe them. If you don't have the knowledge to defend yourself against that, you are going to lose. You are going to lose. And your client is going to lose if you're a credit repair company. The client is going to lose. So we have to educate ourselves. Do not let the ease with which AI is allowing us to move to allow you to neglect gaining real knowledge that will always be valuable once you're a consumer or if you are a credit repair company. Debt collections lawsuit is on the rise. What they are doing, and this is in every major cities across the country, even in rural areas, the collection lawsuits is on the rise. So once you have a client as a credit repair company that has a delinquent account that is controlled by a debt buyer, where the Midland Funding, LVMV from the data is the most aggressive at this time. They're up 325% from their pre-pandemic numbers. They were responsible for a single-digit amount of cases in the system. Now they're responsible for 18%. That means they have stepped up their game big time. Almost every client you will see that has bad credit, 90% of the time, will have a LVMV funding on there. And once that is the case, prepare yourself. More likely than not, the lawsuit will come. But once you understand how to deal with these guys, and they see that you are applying pressure through your disputes and the disputes that you're writing, they will tread softly in how they attack you. Because you can hold that debt collector on the ropes if you understand how to dispute, and hold them on the ropes where they have to provide certain level of evidence. Not the usual evidence where you said, send me a contract with a wet signature. That's not the only way to dispute with a debt collector and demand evidence. When you are disputing with a debt collector, especially if you're disputing and they're coming back verifying the account, you need to know what you need to ask for. You need to understand what you need to ask for so that the debt collector back is against the wall. One of the things that is often said, once you are going to dispute, this is what is often said. First thing, ask for validation. The validation requirement is the easiest for the debt collector to prove. So once you are dealing with debt collectors, you have to be more knowledgeable than just the validation request, because the validation request is the easiest for the debt collector to prove. Most debt buyers, once they are going to be buying the debt, that information will be given to them. so that they can meet the statutory requirement. If it's a debt collector, a third-party debt collector, which is a non-debt buyer, they will be given the information to validate the account by the original creditor so that they can meet the validation requirement. So our dispute with collections has to be more deeper than just requesting validation or saying cease and desist. You need to understand contract law. You need to understand the requirements of what the debt collector need to produce where evidence is concerned to prove the alleged debt. If you don't understand that, the debt collector is not going to take you seriously. They are going to become aggressive, especially if you are just saying, this is not my account. I don't owe this debt. I never opened an account with you. The debt collector is not going to argue with you with that. They're going to keep going because they have paperwork, especially if they have ever communicated with you and have your information. They are going to pressure you. And what they are doing now is going to courts. Over the weekend, the New York Times presented the article that went viral, Surge in Debt Collection. But that article is piggybacking off deeper research that is done in multiple states showing the trend that collections lawsuit is on the rise. If you have clients that has debt by a lawsuit, you need to equip yourself so you can educate the clients. This is not like when you can just go and say, you know what, let me go ahead and request get an attorney, forward this over to an attorney. With that defense, the attorney is going to need their money up front. 90% of attorneys. So and a lot of time the client will not be able to pay it. So for the most part, what we will have to do is educate ourselves. We got to educate ourselves. So understand this. Once you are running a credit repair business, you are going to see collections lawsuit more likely than not once you have certain furnishers there. Capital One, Discover Bank, Chase, Citibank, LVMV Funding for debt buyers, Midland Credit Management, Midland Funding, Jefferson Capital. All of these guys are in the top 10 of people who like to sue. So if you have these on the account, especially if it's been a while that it's delinquent and you don't see them sell off the debt, the original creditor, prepare yourself. So I just want to give you a heads up this evening, very short live, and to tell you, understand the trends that are flirting itself or flowing in the debt collection sector. They're suing like crazy. So be prepared and be prepared to educate your client. Educate yourself. If you need a book that is able to guide you to do your disputes in an aggressive way, my book, Exposing the Collections Game, that can be found at ChironiqueCreditProducts.com. Chironique Credit Products, spelled the same exact way as the university down there, creditproducts.com. Exposing the Collections Game. That book will give you all the legal framework that you need to dispute with a debt collector from a contract law perspective and certain other angles that is not obvious to you. It breaks down to you what you need to ask for and show you what the debt collector more likely than not from what we have from data to have and don't have. That will give you a strategic advantage in doing your dispute. On the flip side, the same principles that I lay out in there are the same ones you can use to defend in a lawsuit and destroy the debt collector. And everything that is laid out there, I give you the court cases so you're not ifing or guessing whether it works. You're seeing that it works. Exposing the Collection Game. You can buy the hard copy on Amazon. You can buy the digital in my in Chironique Credit Products. If you want to learn, the university is there, www.kyreniqueuniversity.com. Mentorship, you will learn all of these things that you need to learn to do what you got to do to help your client and to help yourself. All right, so I will end the live here and I will catch you